Good morning. I think we'll just give it one more minute here before we get going, just to allow everybody to trickle in. Okay. We have lots to cover, so I think we should get going. So good morning, everyone. Welcome to this morning's webinar, and for joining us for National Public Works Week. My name is Jolene Ingrabelli, and I am the Public Sector Risk Manager at BFL Canada. For those of you that are not familiar with BFL Canada, we are one of the largest risk management, insurance brokerages, and benefits consulting firms in Canada, with a dedicated public sector team servicing municipalities in Ontario and across the country. You're likely all very familiar with AORS, the Association of Ontario Road Supervisors, with members including public works professionals from across Ontario, and with most having some responsibility for road operations in their municipalities. As an association, AORS delivers training for members and their staff on a wide range of topics. Earlier this year, BFL Canada and AORS formed a partnership, as both organizations are committed to the public sector community and to providing clients and members with high quality training and educational programs like today. And for those of you that joined us earlier this year, we also had a panel discussion on the Sudbury decision. Today, we have a great discussion ahead with lots of information regarding the MMS and legal defenses. As well, you'll have to stick around to the end for an update on the work that the MMS Task Force has been doing with the 5-year review. Before we begin with the panel discussion, we have a few housekeeping items. We ask that everyone please keep your mics on mute and cameras off to help avoid any technical issues, with the exception, of course, of our panelists. If you are experiencing any technical difficulties, you can always join us for audio only using one of the phone numbers provided in the link. You won't have the video, but you will get a link to view the presentation in full as it is being recorded. We also ask that if you have any questions, and hopefully you have lots, please post them in the chat function. We're not going to use the raised hand function just due to the number of people that we will have on today's session. So please feel free to post your questions. Some of the questions may be dealt with during the presentation, and if not, we will do our best to have the panelists answer any remaining questions at the end of the presentation. With that, please allow me to introduce our panelists. We are very excited and honored to have 3 legal experts with us today. First up will be Paul Martin. Paul is a partner at Lumineers Nixon. He is dual qualified as a lawyer in both Ontario and California, and his practice focuses upon the defense of municipalities, insurers, and corporations against personal injury, property, land use, and commercial disputes. Paul has handled both jury and judge alone trials, as well as numerous contested motions and applications. He has appeared before all levels of Ontario courts. Paul is a frequent contributor to the Municipal Liability Risk Management newsletters, speaks at various forums, including the Society of Public Insurance Administrators of Ontario, the Canadian Institute, and many others. Following Paul, we will have Charles Painter. Charles is a trial lawyer at Dolden Wallace Follett, as well as a national co-chair of the firm's Municipal Defense Practice Group. Since being called to the bar in 2001, he has focused on and practiced almost exclusively in the areas of municipal defense, insurance defense, medical malpractice defense, advocacy, and civil litigation, and has appeared frequently at all trial and appeal levels of Ontario courts. Charles has edited several chapters of the Law of Municipal Liability in Canada, has published numerous papers, case comments, and articles on municipal law and highway maintenance. As a member of the 2012, 2018, and current government task force, Charles was a drafter of the minimum maintenance standards for municipal highways and has recently published a book on the MMS. And rounding out our panel is Sheila Handler from Shillington McCall. Sheila focuses on building, municipal, and public authority claims, professional liability claims, and a variety of insurance claims, personal injury, construction, property damage, economic loss, and motor vehicles. Since her call to the bar in 2001, Sheila has appeared before all levels of court in Ontario. This, of course, is just a snippet of each panelist's experience and talents, and you can check out each firm's website for their full bios. Our agenda today, we will have Paul kick off the discussion, followed by Charles, and then Sheila. We expect to have time for question and answer period at the end, so please, again, feel free to submit questions for the panel in the chat box. Before I hand it over to the panelists, there is a disclaimer. The information and opinions provided in the webinar today do not and are not intended to constitute legal advice. All information, content, opinions, and materials provided are for general informational purposes only. And with that, I will call upon Paul Martin to begin our discussion.
Thank you, Jolene. It's a pleasure to be here with great panelists and with Jolene. And I recognize so many names of people in attendance, so it's great to see you. Jolene, I just want to be able to turn this slide. I know we had practiced it about 15 times before we started, but don't tell here. Okay. No, I see it. I just wanted to.
Do you need to send another request?
Might be. There we go. So I'm going to speak about Lumineers, and then I will speak briefly about retro reflectivity as pertains to the MMS. I'm sure that most of you who are on this call fully appreciate why all of these issues are important. Roadway accidents often cause horrific injuries, and in catastrophic cases, there is often a search for deep pockets above standard auto policies. And regrettably, municipalities often face joint and several liability, such that the 1% rule can equate to millions of dollars. And you're going to see that in some of the cases that we're speaking about today, where the damages exposure is far in excess to any modest contribution that the municipalities might have played. I still don't see the thing there, but let me just request the remote control. I'm sorry about this delay. Oh, here we go, I think. Apologies, we didn't log on at half an hour early and we had it moving, but this is Murphy's Law. When we are encountering roadway cases, it's low-hanging fruit anytime that we are dealing with signage issues, in particular near bridges and so forth. But increasingly, plaintiff counsel are becoming creative when they're trying to find that 1% against a deep pocket entity such as a municipality. And so we are seeing an uptick, or at least I am, in Lumineer cases. That's why we're going to be speaking about it today. And signage as well. You can always find an expert who can convincingly come to court and cite some kind of standard, whether it be the OTMs would be the gold standard, of course, the Ontario traffic manuals, or they can go and find some other standards that you probably never heard of to say, oh, look, you know, there's some problem here and it's all the municipality's fault. Now, normally when I'm giving presentations, I tend to be the bad guy in giving bad news. That's not the case today. This one is it's not a good news story because a person was horrendously injured, but it is a good news story for common sense and municipal liability. This is a trial decision, Morrison Prince, that involves an accident in rainy and dark conditions that occurred just before Christmas in 2015. And as you know, as so many of us know, it gets dark early. And so it was a dark and cloudy night in the city of London. The plaintiff was the one in yellow crossing this crosswalk lawfully. Meanwhile, there was a defendant, Prince, who was turning left with his pickup truck. The defendant agrees that he made an unsafe left turn, and he pled guilty to a POA charge, Provincial Offences Act charge, for the left-hand turn. He was also charged, quite relevant and importantly, with having overly tinted windows, which would have impeded his and obstructed his view on a dark night. The reason the city was involved was because of this one, and I hope that you can see my cursor on the west median. There was a traffic signal / luminaire, and that had been damaged 1 month prior to this accident involving Mr. Morris.
Actually, you
So,
can have my life. I didn't have it easy growing up. So have a nice day, Gaby.
I think somebody needs to be on mute. So as the defendant was making a left-hand turn, this light was out because it had not been replaced in the 1 month after the original accident that was unrelated. Just want to go to the next slide. I think I can. I don't know why this is suddenly becoming a problem. Jolene, can you just go to the next slide and we'll do it that way so that we don't. Thank you. The court ultimately found that there was no liability against the City of London despite this luminaire being out. And it wrote some important decision at paragraph 91. The court must be mindful not to conflate the absence of median lighting with a positive statutory duty to provide median lighting. And this is an important thing, particularly the last sentence of the paragraph where it says the MMS does not establish a standard of care. And it's important to remember that municipalities do not have a statutory duty to provide lighting. That's a policy decision. However, if they do provide lighting, they must do so reasonably and they must maintain it reasonably. Furthermore, as many of you on the call will know, it's commonly said that the MMS is used as a shield to protect municipalities. It's not a sword to attack them. And so therefore, just because you do not meet with the standard in an MMS does not mean you're automatically liable. The MMS standard for luminaires is prescribed at section 10 of the MMS. And as of 2015, when this accident occurred, for conventional illumination, and those are the normal luminaires, the normal street lights that you see. These are not the ones on the 401 that you see that are like 3 stories high and they can light, a kilometer each way. But for the ordinary street light, if 3 or more consecutive, and they have to be consecutive. So if you have missing, working, missing, that's important. 3 or more consecutive luminaires on a highway are not functioning, then you are under a requirement as a municipality, if you want to enjoy the MMS, to repair those luminaires within a time frame as prescribed on the next slide. And as is always the case, the higher classification, road class 1 is your highway 401 400 and needs to be changed sooner than your local roadway at class 5. Now, what you'll notice, of course, is that despite any of these time frames, the 1 month would have certainly well violated the time for replacement that the City of London had to replace that luminaire by. Next slide. The judge in this trial noted that pursuant to 10.5a, as it read in the MMS as of 2015, luminaires are deemed to be in a state of repair if there's less than the 3 consecutive lights, as I had mentioned. And the deeming rule, of course, is important because what it is you don't need to deem a road to be safe if it already is safe. This is just simply to excuse any liability, even though there's a concession that the road is in a state of non-repair. And that is what the judge was inclined to find in this case. And he did deal with a plaintiff objection as pointed on the next slide. The plaintiffs argued that the MMS was amended in 2018, and those of you who have been attending presentations such as this one since Giuliani many years ago, and I know Charles Painter, a fellow panelist, has spoken about this many times. The MMS is sort of in a cat and mouse game with some of the trial judges in terms of always tightening up because it's difficult to sometimes look at a sympathetic plaintiff who's been horrendously injured and to apply the MMS and say, well, sorry, tough beans. But in 2018, there were substantial amendments that further tightened up the MMS. So if you have an accident after May 3rd, 2018, and I suspect that most of us would be dealing with case files that fall into that situation now, given that that was 6 years ago, and most files would be past that May 2018. Lumineers are deemed to be in a state of repair if the number of non-functioning consecutive lights on the same side of the highway do not exceed 2. So they've actually tightened it up even further to say that you need to have 3 on one side of the roadway. And if we go to the next slide, you'll see that what the plaintiffs were trying to say was that there was another median, another luminaire on the same median that was not working. And they argued that there was that the change in the MMS as of 2018 was somehow, could be worked into their favor. And the judge said, no, that's not the case. You really need 3 and they have to be consecutive. And as of 2018, they have to be consecutive on the same side of street in order to find that there is that the deeming rule does not apply. Go to the next slide. I know that what I've described is probably pretty abstract, so let me just explain it a little bit better. You're already aware of the yellow crossing of the plaintiff. You're aware of the defendant striking him on the left-hand turn. You're aware of the missing luminaire. And from what I gather from reading the decision, there was in this same median block, the next light over consecutive would have been missing as well, or it was out. Next slide. And the judge rejected that argument about consecutive, that it was a consecutive missing luminaire, because he said that it was not considered by expert witnesses for the purposes of anything. They had just brought it up at trial fresh. I was not at the trial, so I don't know what occurred, but that would seem to me as a glaring omission on some lawyers' part if they did not figure out that another light that was consecutive had not been working at the time, because that's obviously a game changer. It's a close call for the city in this case because, let me just see that I'm on the right page. At paragraph 100, you'll see that the judge said, I find that these non-functioning lights in any event are not consecutive to the 2 non-functioning luminaires. And then he went on to find out that lighting was not an issue anyhow. And judges tend to do that, whether you like it or not. They tend to sort of bolster their legal finding with the facts as they interpret them. So I have been unable to find any evidence as to where this matter is on appeal. As it's a trial judgment, I suspect that it will be appealed and hopefully upheld on appeal. And again, the real issue will be whether the judge was correct in not considering the other luminaire. But either way, the MMS would seem to have been upheld in this very serious and sympathetic case, and that's a win for municipal liability. If we can go to the next slide. Now, despite my handling of the PowerPoint slides not working today, I have more good news for you to make up for that deficiency. And this is a file that I am dealing with in our office right now, which is the town of Milton being sued. And if you could go to the next slide. This is an aerial map of the area in question. The defendant was going from where you see the CIBC branch with ATM. He was going northerly, I would call it, along Thompson Road South. And when he got past the Noor Collection Fashion Galleria, there was a light pole there that was missing. Not just not working, but absolutely missing. And meantime, there was a young man, 18 years old, who, and I hope you can see my cursor, who was coming out of this walkway on the opposite side of the road and was jaywalking at night, again in 2015. And as you can imagine, he got struck by the plaintiff's vehicle. And just like the Mr. Prince, he has suffered horrendous, catastrophic brain injuries such that he will never work again. And so if he's 18 years old when this occurs, that's many decades of care and income loss. So it's a huge damages case, and there's only $1 million on the defendant vehicle. If we could go to the next slide. Now, the luminaire in question, or the light pole in question, was not just burned out, it was actually missing. So you have a light pole and it has that end there. And our theory under the town's defense is that Milton Hydro, which is a separate entity, was trying to electrify a nearby residential subdivision. And so they removed that light pole from the pole. And when the town went by for the next 4 years doing their annual luminaire inspections, they were just looking, their inspectors were just driving by at night and looking for any broken light poles. They weren't looking for actual missing light stands or light poles and luminaires. So it went for 4 years until this accident occurred. And then everybody looked around and said, hey, this thing was actually absolutely missing. And Milton Hydro brought a summary judgment motion to get out of the action. They were originally successful. It went to the Court of Appeal, and we were successful in overturning that summary judgment motion such that Milton Hydro is now brought back into the lawsuit. They tried to appeal to the Supreme Court, and that was denied. So as it stands, we have a pretrial in 1 month to move this case forward. Milton Hydro is back in the game. And the town of Milton is very vigorous in terms of stating that it has no liability, because even if lighting made a difference in this case, and that is contested, there was only that one light pole. And as you know from the MMS, you need 3 consecutive in order to have any real exposure upon the town. Let's go to the next slide if we can. I was asked to speak briefly about retroreflectivity, and I will do so for about 5 minutes because it's really, when you look at the case law, most of the low-hanging fruit the plaintiff's counsel go after is signage is huge. Like, where did you put the sign? Why was the sign missing? And those sort of issues. And then there's the luminaire issue that we just spoke about. I have been unable to find through any case law searches, any case decisions where retroreflectivity has actually come into question. But as engineering experts working with plaintiffs become more and more creative, sight lines and so forth are always an issue, and it will be just a matter of time before there will be a case that deals with retroreflectivity. Retroreflectivity is, of course, when you're driving at night, you want to be able to see signage just as well as you might during the day. And it is dealt with, this issue, through sections 11 and 12 of the MMS. 11 is dealing with regulatory signs, and I'll come to define what that is in a moment. And 12 is dealing with warning signs. Now, the standard of inspection for these signs is very similar to municipal sidewalks. And those of you who are familiar with how that works, if you look at this section 11 standard, it says the standard of frequency of inspecting signage is to see that they meet retroreflectivity requirements of the Ontario Traffic Manual once per calendar year, and that inspection should not be more than 16 months apart from the other one. And if you find a problem, then you're still deemed to be in a state of repair, so long as you've been doing these annual inspections, unless you acquire actual knowledge. And so that is fairly standard and similar to what you may have with sidewalk inspections. Now, the last part of this is it says, if any sign, if you look at the last paragraph, if any sign of a type listed in subsection 2 is illegible, improperly oriented, obscured, or missing, the standard is to deploy resources as soon as practicable after becoming aware of the problem. And my question to you is, if you're looking at this section, what is required in an inspection? It says that you have to do an inspection once every calendar year and once within every 16 months, but what suffices? Does driving around at night work, or do you need to use some sort of reflectivity meter, which I understand can cost some $10,000 per equipment? And I spent some time looking into this issue in the OTMs. And I was not able to find anything that said the standard for what kind of inspection is required. The closest I came to it was the OTM book 1B as in Bob, Sign Design Principles, that section 15 speaks to inspection. And there, it actually is inconsistent with the MMS. It says that the standard that they recommend is once every 3 years. So they think, and I totally get it. Having done municipal work for more than 10 years, even a small municipality can have hundreds, if not thousands, of lane kilometers. So you just think about how many signage are out there, how many, it's going to be tons, like thousands and thousands. You can't possibly go around and inspect everything to the 10th degree. So what the OTM says is that if you try to do 1/3 of the municipality every year, then every 3 years you will go and do a full inspection of the entire municipality. That would not be a defense under the MMS. I think you're better to do a more generic, full, in accordance with this standard that I have up on the screen. Do it every year. And I think it makes sense to have one person driving with one inspector dedicated solely towards looking at signage. If there are any close calls, and if you have the budget for it, you could have this reflectometer meter that you can use to see if something meets the standards or not. But for most signs, it's going to be obvious whether this reflectivity is met or not. And indeed, that's what the OTM says. They speak about nighttime inspections, and so that's what they do. Now, similar to, we're getting some feedback from somebody.
We'll get.
Yeah, and similar to Lumineers, I think the biggest question that you're going to have is about whether there's a missing sign or whether it's improperly oriented, something like that. And what you really need is a street inventory. You got to keep a log of the critical signs that you have so that you can replace them, monitor them, and fix them. Let's go to the next slide if we can. These are just examples of what are the regulatory signs. These are your important ones. They need to be fixed as soon as possible after you notice. Then go to the next slide. And for section 12 signs, you have slightly more time in terms of when you can repair them. If we go to the next slide. These are some examples of section 12 regulatory signage. And these are going to tell you what you need to do. These are the more important signs that need to be repaired. Go ahead. And then you have your warning signs. So you have regulatory and warning signs. But the standard is set out in the MMS, and it's similar to any other of these even as to Lumineers, where you should keep an inventory so that you know what it is that you are actually inspecting. And I think that takes us to the end of my part of the presentation.
Thank you, Paul. We'll pass it over to Charles.
Thanks, thanks, Paul. That was really great. Very interesting cases. So I'm going to talk about the MMS, and in particular, I'm going to focus on weather monitoring. So what I'm going to do is I'm going to see if I can advance the slides, and if not, Jolene, I'll have you do it, but looks like it's working. So let's talk about the background of the MMS, just to place us into historical perspective. They were created in the 1990s, back when Mike Harris and the Conservatives were running the province of Ontario. And sort of around 95, there was a downloading of roads and bridges from the province down onto municipal shoulders. And that caused some concern, because at the same time, you had increasing litigation against the province, as well as municipal governments, for road claims, allegations of non-repair, causing an accident or some sort of loss. And that led to increasing insurance costs. And the insurance costs became a big problem, as well as a change in the law called the risk-based theory of liability being more prevalent. And in a nutshell, rather than fighting about a failure to get to the non-repair quickly enough to fix it, the arguments became more focused on failing to do preventive maintenance in the first place. And the classic claim is an icy road claim. So prior to the mid-90s, when you sued a municipality for an icy road, they would largely defend the claim on the basis of, well, we got there as quickly as we reasonably could have been expected once the ice formed. The shift has been to arguing that they should have been out salting or pre-treating the highways in the first place to try and delay or prevent the ice from forming. And that, frankly, is a much easier argument to make for plaintiffs' counsel. And so that's where they have been focusing ever since. On top of all of this, insurance costs, the downloading, more claims, you have the 1% rule. That's widely enforced, obviously, in Ontario. The deep pocket defendant municipalities became the target. And one thing I haven't mentioned, but the idea of contingency fee arrangements, where lawyers can sign a client up and the client doesn't pay anything other than maybe disbursements until the trial or settlement. So you had a kind of a perfect storm. And what's interesting is that in response, municipalities lobbied our provincial government, and the government promised some relief. So the MMS were created, and the Municipal Act amended to allow our Minister of Transportation to create essentially a whole new legal defense, largely codifying certain common law principles, but creating a regulatory defense to claims for certain conditions of non-repair of the highway. And as you see here on this slide I've got up, they're outcome based. So they're not meant to dictate how you do a particular task, how you plow a road or how you might apply salt. You know, salt rates are not set. You know, the depth of how high you put your plow on or above the surface of the road, the minutia isn't gotten into so much. This is about outcome based. So the end result is what's dictated under the MMS and the time to do it. And the idea here is to give you maximum flexibility as a municipal defendant. They're also optional, so they're not mandatory. It's still a really good idea to try and meet them if you can, because obviously, if you get sued and you can prove you met the MMS, you should have a full defense, provided the condition is one that's covered by the regulation. So here's a letter from the province of Ontario, from the Minister of Transportation to Michael Power from way back in '97, you'll see, who was the president of AMO, which is an organization that lobbies for municipalities across the province. And it essentially confirms, as you'll see here at the bottom, that the project to create these MMS was a direct response to concern raised by Ontario municipalities about rapidly rising liability-related costs associated with negligence claims, and relief from liability when they have exercised their duty to keep their roads and bridges in a state of repair. And so the minister, Al Palladini, expresses that he was concerned that certain members may not have a full understanding of the intent of the project and invited questions to be made. The important part here, obviously, is that the province has confirmed why the MMS were created, right? They're meant to be a relief from claims. So let's talk about how they actually work. In particular, with respect to winter maintenance, because although burnt out streetlights are often an interesting area of litigation, just like the Morrison Prince case and the Milton case that Mr. Martin just discussed. But snow and ice on slippery roads, I would venture to say, is still by far the majority of road claims that we as litigation defense counsel face. So when you're dealing with the provisions of the MMS for winter maintenance, weather monitoring is where it begins and ends. And so it sets two different types of monitoring, winter and non-winter, essentially. You've got October 1 to April 30. The standard is to monitor the weather current and forecast to occur in the upcoming 24 hours, once every shift or 3 times per calendar day, whichever is more frequent. At intervals you get to determine, so the flexibility remains. But the requirement is at least 3 times a calendar day. And if you have more than 3 shifts, you've got to do it more. And then from May 1st to September, your typical summer fall months, standard is to monitor it once a day. Weather is defined. This is a regulatory defense. So in order to make out a regulatory defense, you really have to comply strictly with the requirements. So the definition of weather is here. It's air temperature, wind, and precipitation. So when you're reviewing your weather, you should be recording it in a log for future, so you can prove to a judge you did it in compliance with section 3.1. And you should be highlighting and noting current and the forecast in 24 hours, air temperature, wind, and precipitation. The idea here is then you have overlap. Each shift within that calendar day is looking ahead from that moment in time for 24 hours. So you've got these overlapping weather monitoring acts that are required. There's another key definition that's very important to monitor, and that is substantial probability. So be aware of this. It means, and this is a fun definition, a significant likelihood considerably in excess of 51%. And this has caused some fun discussion about the lack of clarity of this definition. It's a bit intentional, honestly. The idea here is that, and you'll see how this works in a minute, but the idea is it's not just 50-50. It's not the balance of probabilities in lawyer speak, which is how we prove something in court. To prove something in court in a civil claim, you've got to prove that the thing you're trying to prove happened on the balance of probabilities, so like the scales of justice. So if you can prove to a judge's satisfaction that it's more likely than not that a certain thing happened, then you've satisfied your onus of proof. So when you're dealing with these forecasts and you're looking ahead to what do we do? Should we deploy a winter patrol? Should we send out trucks to start treating the roadway in advance, say of a predicted freezing rain event? You're going to make that decision in reality, not on a 50% chance in the usual course, certainly in my experience. But what I see typically municipal road authorities do is that when there's a high probability of a winter event, when you know that the time, energy, and money is worth spending, then you send the troops out and you start doing the maintenance. And so this is reflected in that substantial probability definition. right? We leave it, as we should, I would argue, to the experts, to the municipal road authorities who do this job year in and year out, whose kids and spouses and loved ones are traveling on the same roads in town that they're out trying to plow and keep safe during the winter, right? We leave it up to them. So, patrolling. And I'll back up here. The Giuliani case that Paul talked about, once the MMS were sidestepped by our trial judge, began with the failure to monitor the weather properly. And the way that the court did it, and in future we could see would be the way, is they'll say, you didn't monitor the weather properly, you failed to see the forecasted weather event that unfolded, you failed to deploy your troops out earlier than you ought to have, which led to the road becoming slippery and dangerous earlier and longer than it should have. And had you just done your weather monitoring at step one properly, it would have led to someone having plowed or salted that road before the accident. And that's the game, right? So we created this very basic and very straightforward weather monitoring standard to create a very strong, I hope, defense for municipalities. So it's really the key, because it's the first step in many of these cases where alleged non-repair in the winter is brought up. So patrolling, 2 different times. Regular patrol, or what we used to call the routine patrol standard, is in section 3 sub 1. So regular patrol is set out in a table. And what there is in this section 3 is each class of road has a different interval for routine patrol. The winter patrol is in sub 2. If it is determined by the municipality that the weather monitoring referred to in 3.1 indicates a substantial probability of snow accumulation on roadways, ice formation on roadways, or that there's actually icy roadways, then in addition to your routine patrol, you send out a patrol on your representative highways at intervals deemed necessary by yourselves to check for these wintry conditions. So you see the substantial probability kicks in this winter patrol decision. You're monitoring the weather. You're looking at the forecast. The forecast suggests to you not just a 50-50 chance of icy roads, but a much higher probability, such that now you're going to decide to send out your patrols to keep an eye on things, right? All begins with weather monitoring and then moves to the patrol decision. Now we're into icy roadway standard. And just to help sort of bookend this discussion. So you'll see the MMS talk about what to do. There's 2 times. There's before the ice forms and there's after. We can go back 1 slide, please. Thank you. So section 5.1 says the standard for the prevention of ice formation on roadways is doing the following in the 24-hour period preceding an alleged formation of ice. Number 1, monitor the weather. It's the first and most important thing to do consistently and record proof that you did it. 2, patrol in accordance with section 3, which I've just discussed. Sub 3 then says, if the municipality determines as a result of monitoring the weather or patrolling that there is a substantial probability of ice forming on the roadway, then the standard is to treat the roadway, but only if practicable, to prevent ice formation within the time set out in the table, starting from the time that the municipality determines is the appropriate time to deploy resources for that purpose. So you'll see, once again, substantial probability features prominently here. And you'll see that if you monitor the weather and patrol, then you've got to consider if and when before an icy condition forms on your roadway, that you should be doing anything, right? Not everyone has the equipment or the manpower or human power to go out and pre-treat roadways. So you have the ability to decide, but it all comes back to making the substantial probability call. And the beauty of this section is in 2 here. If the municipality meets the standard set out in subsection 1, and despite such compliance, ice forms on the roadway is deemed to be in a state of repair until the time in the tables in section 2, table 2, expires after you become aware that the road is icy. In other words, you can have an ice-covered roadway and you can't be sued for it because you monitored the weather, you sent out your patrol, you thought about whether or not it was practical to do anything to treat the road before the ice formed, and unfortunately, Mother Nature did her thing, and the ice formed on the road, and there was unfortunately an accident, right? You have a full defense. We go to the next slide, please. I'm going to talk next about significant weather events. A municipality under the MMS may declare a significant weather event in accordance with the regulation at any time in its sole discretion it elects to do so. Go to the next slide, please. Under the regulation, the municipality can declare a significant weather event specifically in respect to what are called weather hazards. Now, these are defined by Environment Canada under its public alerting program, and they're incorporated by reference into the regulation. And so for municipal road supervisors and managers involved in maintaining the highways and making the decision about whether to issue a notification of a significant weather event, you should become very familiar with the Environment Canada weather hazards. And you can see they cover not only winter conditions, which is where we've begun, but we're working now to expand the significant weather event in our current task force to cover other conditions, such as severe wind events like a tornado or a tropical storm, where signage may get knocked over, luminaires get knocked out. So you'll see there's quite a variety of winter events covering pretty much everything that could possibly happen, although I don't think a tsunami is likely here in Ontario, but you never know. Next slide, please. Here's an example. So what I did is I've copied from the Environment Canada website two of the weather hazard definitions. So for snowfall, which is one of the most common, for Ontario and elsewhere except Nunavut, you've got 15 centimeters of snow falling within 12 hours or less. So if you're looking at a forecast and the forecast is you're going to get 20 centimeters of snow in the next 12 hours, that, in my humble opinion, means you should probably be issuing a significant weather event alert to the public under the MMS and in accordance with its requirements. I'll explain why that's important in a minute. Flash freeze is another defined weather hazard, and you'll see that when significant ice is expected to form on roads, sidewalks, or other surfaces over much of a region because of the freezing of residual water from either melted snow, rain, or due to a drop in temperatures. Next slide, please. So, how you do it? The regulation is clear. It says a municipality declaring the beginning of a significant weather event or the end of one, because there's a second declaration that's made to end it, must do so in one of the following ways. So here it is rather prescriptive, and this is posting on the website, social media announcement, sending out a press release, sending out notice through the municipal police service, or other method as set out in your public notification bylaw if you have one, and most of you do. Next slide, please. Here's an example. People ask me often, how do we do it? So I've always said this is a pretty straightforward process. You simply have to identify specifically the time when the weather hazard notification, the significant weather event notification, when it begins. So in court, there's no question as to the beginning, and what it is that you're warning about, what the significant weather event declaration covers. So here you'll see the draft says pursuant to section 16.9 of OREG 23902, that's the title of the regulation. As amended, the Corporation of the Town of Charleston is hereby declaring a significant weather event in respect to snowfall, freezing rain, and blowing snow. So we've included multiple weather hazards for the event that's coming. Effective at 1 o'clock local time and shall remain in effect until further noticed. And then everything else is just extra, right? Up until that is all you really need to do. But we've thrown in the extra just to say to a judge, look, we warn people right? The aforementioned weather hazards have the potential to pose a significant danger to users of the highways within the town, and therefore extreme caution is advised and unnecessary travel is not recommended. There's your template. Next slide, please. What to do once you declare it. So after you issue the declaration, there is a standard for repair. Right now for winter hazards, we're gonna, as I say, we're considering expanding this to the other sections for signage, for luminaires, shoulder drop-offs, anything that could be damaged or affected by a weather hazard. You'll see under section 4.1, which is the snow accumulation standard, if a municipality declares a significant weather event relating to snow accumulation, the standard for addressing snow accumulation until the end is declared of the significant weather event is to continue monitoring that weather in accordance with section 3.1, and if deemed practicable by the municipality, to deploy your resources to address that snow accumulation, starting from the time you deem it appropriate. Now, you might not, it might be too dangerous. You may not have drivers available, but that is the standard during the event. Keep an eye on the weather, send out the troops if you can to try and deal with what's happening. Next slide, please. At the end of the event, you have to declare the end when you decide it's appropriate to do so and address snow accumulation in accordance with section 4. So you're back to the table time and the depths depending on the class of highway. The beauty of this is you don't have to declare the end until, right when the last flake of snow falls, for a snow accumulation example. You can wait until you've got the roads basically cleaned up and under control, and you're satisfied that with what the remaining time will be after you declare the end of the significant weather event, you'll be able to very much have cleared all the roads in town. There's no rule that you have to declare it right away, and I suggest doing so at a reasonable time, but not too soon. And we have similar wording for sidewalks and similar wording for bicycle lanes for section 4. And section 5 IC roadways has, again, the same type of setup for significant weather events. Next slide, please. So that's significant weather events and weather monitoring. I'm going to give everyone a little peek at what we're looking at on our MMS task force. So as indicated, I'm a member of the task force. I work with Good Roads and the Ministry of Transportation and a number of municipal volunteers from across the province who are looking at the regulation and trying to think up ways to make it better and perhaps expand it to areas that it hasn't touched on yet. And we've spent quite a bit of time working on this and continue to do so. So as I mentioned, we're looking at expanding significant weather events to non-winter type situations involving wind, flood, wildfires, smoke, that kind of issue. We're looking at standards perhaps for crosswalks and driveway aprons, which are not covered. We're looking at reviewing the definition of substantial probability to see if there's any way to improve it beyond what we have now. We're looking at section 5, which is the icy road standard, to look at the timing of when ice forms and how that's fitting into things. Very often, there'll be an argument over when ice formed, and you have to have battling forensic climatologists. We're trying to think if there's a way to avoid that expense in that battle of the experts. The use of smart phones or electronic inspections for various infrastructure under the regulation. Looking at luminaires at intersections, just to see if cases like the Morrison Prince case can be improved on and codified in the MMS, because at an intersection, one of the fights is, well, which direction are we looking at for 3 consecutive? Is it this way? Is it this way? If it's in the middle of the intersection or on an island, how does it get counted? We're gonna try and clear that up so that in future there's no debate. Flashing beacons as an enhancement to certain signage requirements, we're looking at that. Intersection inspections, the pedestrian signals, heads, and push buttons are not currently part of the inspection for traffic control systems. And surface discontinuity measurements, how you measure a trip ledge, how you measure roadway surface discontinuities. There's case law that suggests averaging the height might be the way to go, especially if the plaintiff doesn't remember exactly where their vehicle hit the 5 centimeter surface road discontinuity, or where the toe touched the 2 centimeter plus trip ledge allegedly and fell. So those are just some of the things we're looking at, and we're going to continue cracking away on. So thank you for your time. And if there are any questions, I'll be here right until the end.
Charles, I think I'm just going to jump in with one question that's in the chat.
Sure.
And it's a good one about weather service. So does subscribing to a weather service, Weather Logics, for example, does that automatically sends detailed weather reports 3 times per day between October to April, meet the requirements to monitor the weather?
Yes and no. Yes, because it's going to have air temperature, wind, and precipitation data, and it's probably going to be forecasted. It's not going to give you just the current. It's probably going to give you several days ahead, not just the 24 hours. But the key is, in court, you've got to prove that somebody at the municipality not only received the email with that forecast, but that they looked at it, and that they can say in their diary, or even what we've done is I've had people print a copy, sign and print their name, and take a yellow highlighter and circle air temperature, wind, precipitation, current, and then 24 hours ahead, so that I can say to a judge, look, my client, Mr. Jones, the traffic supervisor, on January 10th of 2024, he monitored the weather in accordance with section 3.1 that day, and it was done every shift. So the key here is consistency, right? And Sheila, I think we'll talk about a little bit of this more, but consistency and tight record keeping. It's kind of easy, I would suggest, but the problem is the more paperwork you give staff to do, the more likely it is it's going to fall through the cracks. But anyway, those forecast service, the Mateo Group ones, the Arwis forecasts, they're all excellent. But just show how you looked at it. And anyway, I don't want to steal Sheila's thunder. She'll talk more about this.
Well, thanks, Chuck. I completely agree with you on that point, and I'll address it a little bit too as I move forward. So thanks, Charles and Paul. Great presentations. My part of this talk is just it really is about proof and how we prove what a good job road supervisors and municipal staff are doing throughout Ontario to keep our roads safe. And I would argue with anybody that probably for the conditions we face, Ontario has some of the safest roads in the world. What I'd like to talk about is how do we prove that we've done our jobs properly, that we've done all of this good work. I know you've all heard this talk or other versions of this talk probably many times before, so I'll get to the point. And you know that the outcome is going to be records and keeping track of the evidence. So I will just move forward as quickly as I can because I have too many slides, and I have to ask for control here. Okay, and there we go. All right, so first of all, I'm going to talk about 2 cases. I'll move through them quickly. They're 2 municipal cases. It's a tale of 2 cities. I'll try to be a little bit faster than Charles Dickens. The first municipality is Wilmot near Kitchener, and I'm quite pleased to say that they won a trial. They won a case at trial, a road maintenance case at trial and on appeal, which is a great result. And how did they win it? They won it because they could prove their defense. I've just excerpted here on slide 40 a summary of some of the evidence about the conditions. And one of the observations I'd make, and I'm sure that you all understand this implicitly, is that everybody seems to be using a different definition of icy conditions, snow, slush, and so on. So almost every winter case you see, you'll have the police officer who describes the road conditions in one way, the witnesses describe it in another, nearby residents or first responders describe it as something else. And hopefully we get some pictures or something of the scene within a reasonable time. And in many cases, actually, a lot of the pictures that are prepared by the police are taken during the course of an ongoing weather event. So it looks much worse after the accident than it might have looked at the time of the accident. So, and I just raised this because from our municipal point of view, I think it's important that we all try to work towards common definitions of these things and see if we can slowly get everybody on track to be able to use the same words to describe the same conditions. In any event, the Wilmot case, it went to the Court of Appeal. Municipality won, of course, plaintiffs appealed. And one important note is that it was basically accepted in this case that the finding of the trial judge that there was ice on this road, it was this unanticipated ice that formed, and it was melting into slush, and the road was slippery, that amounted to a failure to keep the road in a reasonable state of repair. And so often that means in these cases, when there is a condition on the road, a slippery condition that caused the accident, we're already put into the defense mode. And that's going to be important when I talk to you about the onus. And in that case, basically, they succeeded because they were able to prove that the forecast didn't really forecast the icy condition, and it was an unanticipated icy condition, and therefore they met all of their defenses. And I'll talk very briefly about the defenses later on, but you know them all, right? That the municipality did not know and couldn't reasonably have been expected to know about the condition, or that it had a reasonable system of inspection and repair that was complied with, or the MMS defenses. In this case, Wilmot met all of them because it was established that the ice was unanticipated. So that the court in that case was satisfied that Wilmot looked at the forecasts appropriately, carried out appropriate patrols. The area in question was not a known trouble spot, and it was unanticipated. And being able to prove these things was crucial to establishing that defense, and crucial to Wilmot's success in the case. So I'm going to go to another case. It's a Hamilton case, and this is just for comparison. It sounds like this case was winnable. In fact, Hamilton won it at trial. And the reason why it lost on appeal just had to do with the onus of proof. So this was just a motorcycle accident on a 5 centimeter surface discontinuity. And Hamilton received notice within the 10-day notice period. And it didn't, Hamilton didn't go and take pictures of the surface discontinuity or measure it or anything like that. I don't know too much about the case behind the scenes, but it may be that Hamilton was supplied with pictures by plaintiff's counsel and thought it could rely on those. But in any event, it didn't have the evidence available at trial to prove that the surface discontinuity was 5 centimeters or less. And therefore, the plaintiff was able to, it had an expert who testified that it was, slightly greater than 5 centimeters. And essentially the trial judge believed that it was 5 centimeters or less. And that's why Hamilton won at trial. On the appeal court, at the appeal court, the Court of Appeal was focused on who had the onus to prove what. And because Hamilton did not have the evidence to prove its defense, it lost. And that's a very legalistic way to look at it. But unfortunately, that's what we're up against. So with respect to the defenses, it's up to us to prove that we can make them out. And I'm going quickly because I have too many slides. So please don't hesitate to put any questions in the chat, and I'll try to get them to you. And so I guess one point is that we have to, and this will be primarily the lawyer's job, but we sometimes get the case much later, and we have to start thinking about proof even all the way through the process. And when we think about proof, we have to think about the records and the photographs and the measurements and so on, but we also have to think about the credibility of that proof. And that's, you know, the location of the measurements, the angle of the photographs, notes and records about the measurements, the metadata on the photographs, all kinds of things. Because when we get to court, the other side is going to be looking for errors in our evidence. They're going to look for some way to attack our defenses. And that's why we need to focus on doing as credible a job as we can at gathering this evidence. And so the takeaway about these two cases is that if we can prove our defenses, we can win. And if we can't prove our defenses, then we can lose winnable cases. We're probably always going to lose the losable cases, but you know, if we can win the winnable ones, that'll be good. So let's talk about the proof for a minute. And the first thing I want to talk to you about is the notice. And this is this comes up a lot, actually, the missed notice period. So municipalities have this entitlement to notice of a claim within 10 days. There are some sort of exceptions in some cases, or there are, you know, some things that might be considered a reasonable excuse for not providing notice within 10 days. But the point of the 10-day notice period is to allow the municipality to gather evidence of the circumstances of the accident, of its response to any conditions of non-repair, and essentially to allow it to start organizing its defense of the claim. Municipalities, as Paul has pointed out, are often very, very large, and you know, it's not like a Costco. They don't, you know, you can't close it up at night and lock everybody out. I mean, people are going around all hours of the day. So it's important to municipalities to be able to get that notice and to be able to go out and investigate the claims. When we're defending a case and somebody has failed to provide notice, we can sometimes have the claim dismissed on that basis. But in those cases where notice was not provided, the plaintiff has to prove that they have a reasonable excuse for not providing the notice, and also that the municipality is not prejudiced in its defense, and they bear the onus of proving those things. Now, the fact is, though, if we don't have, if they provided us notice within 10 days and we wouldn't have done anything about it, then it's hard to prove that we would have been prejudiced by the failure to provide notice. So this comes to my first suggestion is and I've seen this quite a bit, that where the notice comes in, the municipality doesn't do any initial investigation or arrange for it. Many municipalities do right away, and they retain outside adjusters, or they have their own risk management staff go and take pictures and make records and so on. But it's, I think, important to develop those practices and protocols and to adhere to them, so that if in a case we find that we didn't get notice in time, we can point to those practices and protocols and say, if we had received notice, we would have taken these steps. And those steps would have included taking photographs, interviewing witnesses, and so on. Now we're interviewing the witnesses 2 years later and they can't remember a damn thing. That helps us to establish prejudice. And that may help us to do two things. One, to be able to better defend the municipality in the first place, which is the point of the 10-day notice period. And two, it helps us to prove any prejudice that arises from the failure to provide the notice. So that's my first suggestion, is to see if there's a way we can get better at establishing what our practices and protocols are around notice, what we would do, and that we would be preserving evidence with all due dispatch as soon as we get the notice. If we're not, then it really doesn't matter if we get the notice from a prejudice point of view. And so that's why I think, that's why I make that suggestion. So I mentioned the word onus a couple of times, and I think we all know what it means. It means that it means the burden, right? So we have the burden of proving something. And I mentioned with respect to the notice that if notice isn't provided on time, the plaintiff bears the onus of proving that they have a reasonable excuse and that the municipality wasn't prejudiced. With respect to the claim proper, the plaintiff has to prove that the road is in a condition of disrepair. So that's 44 sub 1 of the Municipal Act. And they also have to prove that the disrepair caused or contributed to the accident. So it's got to be somehow relevant. The issue of disrepair has to somehow be contributory to the accident in some way. And then the municipality has to prove any defenses that it makes under section 44 sub 3. And we also have to prove any contributory negligence of the plaintiff. And it's not just, sometimes we think, well, how could this accident happen? Obviously, they're negligent. We actually have the onus of proving that. And so that's why sometimes we're working hard on that issue that sometimes seems so obvious. Now, we've talked very briefly about the defenses. You know what they are. The first one is that the municipality did not know and could not reasonably have been expected to know about a condition. And the idea here is that the condition developed suddenly. It's sort of like an innocent ignorance defense. And the idea is that that we didn't have time to address the condition which suddenly developed, and it wouldn't be reasonable to expect us to know about that condition before it occurred. So it's typically wouldn't apply to things that are forecast like the weather, but it can apply to things like a sudden development of a massive quantity of goose poo or June bug goo or something in a particular location that nobody would have foreseen, or a contractor drops something off of a big piece of lumber off the back of a truck, or dead deer on the road. And with this defense, as soon as we know or should have known about the condition, then the time starts to run out on the defense. Then we have to be responding reasonably to the condition that's developed. I think it's also arguable in cases where the condition is something that you wouldn't ever really inspect for. And, an example would be, like you've got these snowbanks, right? You've gone and you've done all this work, you've cleared all the roads, and you've got snowbanks that obscure the view at an intersection for a driver in a particular, low car, like a sports car, or, they're approaching the intersection from a very particular angle. And, it would be impossible for municipalities to inspect for those kinds of things, or conditions that wouldn't necessarily be visible. Then I think conditions that we wouldn't be expected to know about, I think are, and that we did not in fact know about. This defense could be used for those sort of out from left field claims. And in terms of the proof of this defense, I mean, we're usually calling a witness who says, I didn't know about it, and we wouldn't inspect for it, or we did inspect for it, but it wasn't like that when we inspected. And then we'll get into the expert evidence, but it's almost like proving a negative in terms of proving this defense. The other common defense, and what used to be more common than it is now because of the good work of the MMS committee, is the reasonable system of inspection and repair defense. This one is in where there is an MMS standard. This defense is a little bit more challenging unless we can somehow rely on some local condition which might perhaps make the MMS effectively inapplicable in a location. And I guess the reasonable system of inspection and repair defense will still apply to conditions not covered by the MMS, or maybe sort of hybrid conditions where somebody's pointing to a bunch of things all at once, and we'll be relying on a system and the reasonableness of our system overall. To make out the reasonable system of inspection and repair, we have to prove that A, there's a system, B, what the system is, C, that the system is objectively reasonable, and 4, that it was complied with. Questions 1, 2, and 4 will all depend on the records, essentially. I mean, that we have a system and what the system is. Somebody's going to expect some kind of record of the system, something that we can point to show that we have a system, and that it's not we haven't just sort of extemporaneously made up a system once the claims come in. And then we need to be able to show that that system was complied with. So that's all going to depend on available records. The objective reasonableness of the system will ultimately come down to a beauty contest between the plaintiff and defense theories about what a reasonable system would look like, or how a reasonable system would be. In any event, that would be expert evidence. And we'll probably be having enough to be getting on with when we just think about the evidence we'll need to establish the existence of the system, what the system is, and that it was complied with. So which takes us to the MMS defenses, which are, because they're laid out so clearly, this has now become a really big focus of defending municipal road claims. And now I know there was a question about the weather, and I'll get to that in a second. There are many things that are covered off now by MMS standards. It's really been growing over the years since it was first introduced. And to rely on an MMS defense for any particular item, obviously, we need to be able to prove compliance with the wording of that particular defense as it existed at the time of the accident. So sometimes we're going back into older versions of the MMS, and then we need to look at what is it that we're relying on, and as a defense, and how can we prove that we met that particular defense. So, and that's just to say that every claim is different. And every municipality is different. Different municipalities keep different kinds of records. But at the end of the day, what we're trying to do is to make out particular defenses under the MMS in most of these claims. As Charles pointed out, the greatest source of claims is winter claims. And this is also one of the it's maybe one of the most worked over sections of the MMS, and it's got a sort of a very clear sort of structure as to how it works. And so I'm going to talk about that in a minute a bit more, but just a quick summary. We need to prove not just that we get the forecasts, but we check them 3 times a day. We need to prove that we've made a determination based on our checking of them. It's not enough, it's not enough just to look at them. We have to think about them, and we have to think about them in a particular way, and we have to be able to prove that we thought about them in that particular way. With respect to patrols and observations, we have to prove that they occurred and what they were, and we need to prove the conditions that existed and when and where they existed with the patrols, and ultimately that we did winter response within the timelines according to the class of road and the conditions. And often we're also asked to prove the road classes, provide our AADT records to prove that this is a class 2 road versus a class 1, and so on. And we've alluded to this. I think everybody has alluded to this, but this is kind of what it feels like we're up against when we're producing the municipal records, because we know that the other side is going to take our records and scour them like the eye of Sauron looking for the one ring to rule them all. It's relentless, and the criticism that we get is relentless. And obviously this is because, there's we work in an adversarial system, and people are looking for money for people who are often very seriously injured, and they're going to turn over every stone. So just from a 30,000 foot level, I mean, how do we prove things? Well, we prove things with witnesses and records. And records are key here. They're the main way that we prove the defense case. And I say this even though usually or very often records are going in through witnesses. And in theory, some records can go in as business records, but in practice, we have to call the person who made the record to come and testify about it. The things that we need the witnesses to be able to do are to authenticate the records, testify about the records, and interpret the records. And sometimes the witnesses may have actual memory of the events. That's often unlikely if it's just a snowplow operator who didn't observe the accident, or a snowplow operator for whom every sort of shift is very similar to the other shift, and years have passed. But so then they'll be relying almost exclusively on the records. They may be able to talk about their practices and how they did things, and they may have enough memory to talk about their practices and how things were done. And so then we need them to be able to say or explain how things were done, and in a coherent way. And if we're calling 3 snowplow operators and they're all describing a different way that things are done, it could be a little bit problematic in terms of the way the evidence is looking. So one of the problems we often face too is that things are taking a long time to get to trial, which means it makes our witness recollection problem worse, but also it makes our reliance on the records even greater. And I'm quite confident in saying that most municipalities are not doing things the same way in 2023 that they were doing them in 2015 or 2016. And you might have had reorganizations, you might have new equipment, you might have new computers. All kinds of things have probably changed, and it's very difficult to remember how things used to be in what particular year, because it all kind of blends in together. And so sometimes we need records that go beyond the strict interpretation of the defense, because we might need to prove some of the context and how these things are done or were done. And we're looking to help the witnesses be able to refresh their own memories so they can explain what happened or how they did things with some confidence. And here, just as motivation, just think of how much easier it is if you're looking at a document, the org chart from 2018, to remember, who you would have reported a condition to, or how it would have been done. If you're able to look at that document, and then it will refresh your memory, versus, the risk that you take is if we testify and you don't have that document, and your evidence is kind of all wrong, and somebody comes up with that document later, it just becomes problematic. And this is another reason why this 10-day notice period is important, just because of all of the changes municipalities go through, and they're often, significantly sized organizations. And, we need to get our hands on the witnesses, get their best recollection as early as we can, and then start to preserve documents and records as early as we can. And I know this sounds just disjointed, but records and witnesses are almost like 2 sides of the same coin, because years later, witnesses aren't really going to remember a lot. And so we need the records, and the records will help the witnesses understand what happened and refresh their own recollections about the way things were done at the time. So the question of what to gather and why really varies with the claim and what we need to prove. As I indicated already, the most important thing may be to get the witness statements and photographs and measurements even taken as quickly as possible. Preserving any audio that we might have, video, GPS, raw data, and other electronic records immediately would be great. On the GPS raw data, this has happened a couple of times that I've seen. If the municipality changes GPS providers, what happens to the raw data? Because if we don't get notice, this could be an example of prejudice. We don't get notice within 10 days. We might not preserve the raw data within 10 days. But if we do get notice within 10 days and we don't preserve the raw data, then the prejudice will be on us. But with respect to the raw data, my recommendation here would be when we're switching providers to make sure that we get to keep the raw data and that we own the raw data, because it's very valuable data for us in defending the cases. Another thing that I've seen is some days have more than one accident. It could be like, if it's a bad weather day, you could see a couple of accidents. You could see a couple of claims from those accidents. I had one case once where my accident had no records. All the records from my accident were gone, and we sort of tracked it down, and it's like, well, they all got sent to some other law firm to defend the other accident. So, we need to maintain the integrity of our files and be making sure that we at least retain copies or send copies of the records, and make sure that the municipality maintains a complete copy of its record. Now, when we get to trial, somebody may want you to bring the best evidence and the originals to court, and that's fine. But we just don't want to be losing track of where all of our records are going. And what else are we gathering? We're gathering evidence for the applicable MMS and other defenses. So we should look at the defense and try to figure out everything that we can throw at to prove that defense and to prove that we met all of the elements of that defense. So this will take us to the weather monitoring. And as Charles said, it's not enough to just receive the forecasts or to have forecasts emailed to a whole host of people and just assume that somebody read it. We have to show that somebody checked it and that they thought about it, and that they made a decision about whether resources need to be deployed or not, based on the contents of that forecast. And so, and you probably know all this like the back of your hand, but the whole MMS system for the road maintenance is like a pyramid. So it starts with the forecasts, then it's patrolling, and then it's responding. And the first part of it is the weather monitoring. If we don't get that right, we're going to have some problems. So we need to show it. And what we need to show is that the substantial probability determination was made as well. So we need to show that we looked at the relevant parts of the forecast, which are the air temperature, wind, and precipitation. And then that we thought about the substantial probability of snow accumulation on roadways, ice formation on roadways, or icy roadways. And that takes us to patrolling. So my next suggestion on this is that the best way to show why we're doing things is to have a contemporaneous record of it. And the best way to show that we are making this substantial probability determination is to have a record of that. Based on what I'm seeing, a lot of the forecasts are coming in now by email, or they are electronic documents. And it seems like the easiest way to prove a review of the forecast would be to receive it by email, and then send an email to a superior or a team, or somebody at a dispatch, something just saying, you know, I've looked at this forecast and, you know, based on the air temperature, wind, and so on, precipitation, you know, this, you know, I don't believe there's a substantial probability of snow accumulation or ice formation, and then explain, you know, what's going to happen next, or, you know, maybe there is a substantial probability of snow accumulation on the roadways, you know, starting at 7 p.m. And so, you know, we'll start patrolling at 4 p.m. and, you know, we'll do call outs at 6 p.m. or something like that. But just looking at, the conditions and then explaining why your crews are out patching potholes that day instead of dealing with the road conditions. And what we see in the records often is we get the diaries and they sort of say, you know, these crews are patching potholes, and plaintiffs' counsel saying, why are they out patching potholes? And the answer is obvious, like, because doesn't look like there's any weather to address. But if we just say that more explicitly, it becomes clearer to the other side. And this can be done in paper, as Charles suggested, highlighting and writing your determination on the record, and then you have to keep the paper record, and you have to make sure you're keeping all the records and that it's going on 3 times per shift. From my point of view, the advantage of the email approach, you get it by email, you type something up quickly and you send it by email, is it's time stamped and date stamped, and that adds a layer of credibility to it that you did it at the time. But what we really just need to prove is that you care, you're trying to make reasonable decisions, and you're actually taking all the right steps. And so that's the goal with that. So patrols, a lot of municipalities, I think, are doing patrols not just because of the substantial probability of ice formation or so on. I think they're often municipalities are patrolling quite regularly in winter weather or not. They've made this substantial probability determination. Patrols ought to be recorded. My ideal would be photos and metadata with geolocation, but you know, most municipalities are probably not there. GPS can show where patrollers patrolled, but it doesn't necessarily show where they made any observations, unless maybe they pull over and stop for 3 minutes and make their observations at a certain spot, and then we can, you know, if they record their observations and we see it, then we could maybe look at the speed equals zeros to try to line those things up. But usually for patrols, we're still relying on paper records, and those should say the date of the patrol, the time that any observation was made, where the observation was made, and what was observed, and who observed it, because we'll probably need, or we may need to call that person as a witness. The information needs to get back to the decision maker, and record should be kept of the information received and any decisions taken in response to that information. You know, we're trying to show how our system is rational. So we send out people to patrol. If we just ignore the patrols, that's not going to be great. So we need to, you know, the patrols are coming back and they're saying the roads are still good. Therefore, you know, we're still good. We're not going to do anything. We're going to call people out once a patroller is starting to say that there's a condition developing that we need to respond to. So just keep that recorded. Just think that somebody's going to ask why you did or did not respond to information, because now we're making all these records and some of them are going to record conditions. Somebody should be aware of those conditions recorded and be able to explain why they did or did not take some course of action. Representative roads, it's okay to use them. I would suggest they should be selected in advance. It makes it easier to prove that they're actually representative. Not that we really need to. Representative roads are something that are up to the municipality to determine. But we do get asked a lot of questions about how these roads are representative or whether they're actually representative. And, you know, if we can nip that in the bud, that would be useful. Maybe have, you know, sit down and try to get roads of various classes in the mix, north, south, east, west, and so on, maybe some for each quadrant or zone, and try to cover off the municipality in a sort of rational way that we can point to say this is how we came up with it. It would tend to nip that in the bud and be helpful. I would love to have dash cam footage with the patrol vehicles. I really would. That would be fantastic. I really think we're getting into a really exciting place for proving our defenses on these road claims with technology. It's really going to make some of this very helpful. I mean, it's there's so much potential. It's also so much expense. But that would be fantastic if we could get pictures, and we could say this is what it looked like at this time. It would just make our cases so much easier to defend. So again, I'll just skip to the upshot. If we can prove our defenses, we can win these cases, and we need the proper proof that's admissible in court and credible. And the credibility is going to be key. If we properly maintain our computer records and preserve it, GPS, photos with metadata, geolocation, those kinds of things, that's considered very credible, because you know, you pretty much have to be a software engineer to mess around with it. Of course, you know, that's all changing, but paper records these days are useful, particularly in a lot of areas. They're sort of all we've got, but they're considered a little bit less credible, and it's doubly so if they're confusing, not filled out well, susceptible of multiple meanings, or we have to, you know, go back and ask somebody what they meant, you know. So sometimes we see a lot of this, like, you know, what does this mean? And it just makes it harder to prove. So common criticisms, some municipalities aren't getting, different GPS providers provide different kinds of detail, different levels of detail, and it may be different packages that you have to pay for. But like plow up or plow down, if that's not included, that's, you know, criticized. It just means that we have to rely on the fact that the plow operator did it right. And you know, the plow operator will come and testify that he did it right. But you know, it's nice to have the plow up or plow down. Sometimes the records can be wrong, you know, backwards, or the devices can be locked in a position or something like that. And we need to deal with that with other sort of computer or device evidence. A big problem with GPS data is it can sometimes be missing altogether. And so we'd like to avoid that as much as possible, and maybe start keeping track of the fact that we're actually, you know, our plows are out there, and are they sending back the, you know, have the IT people see, like, are we getting the records? Is it there, or is this one not sending? And trying to get that fixed as quickly as possible. Inconsistent record keeping practices. I'm sure you've all heard about that. You know, John uses X's, Jane uses check marks. Dave has a straight line through all the streets, and that means he did them, but he's got a squiggle over here. And now we've got to go back and find out what the squiggle means. Does it mean the same thing as a straight line? You know, it just, it's not as good as if we're really consistent with the records. Missing dates and times, of course, and different kinds of records from different people. You know, we have a bunch of supervisors, and they all come one after the other in the shifts, but they all keep their records slightly differently. That's that becomes confusing, and all of these areas of confusion are sort of weak spots for us. And then one thing that I've noticed too is where beats and routes aren't defined or laid out in order, or where the operators can do the routes as they kind of choose, we can get into problems. So I recommend GPS modules be working, that we try to get IT involved to make sure that they're that we're checking that we're getting the data as it's coming in, and that any fixed or broken GPS units are fixed right away. And to try to get as much on GPS and to preserve GPS data if we switch providers. I'm sorry, I'm going way over, but there's so much here. One thing to think about is that any given accident is in a particular place at a particular time. And when we're dealing with the circumstance and litigation, we lawyers and judges, we're all fixed on this one particular place and one particular time. But the municipalities are clearing, hundreds of kilometers of roads, and their records are, for large distances and over a period of time. It might take 3 hours to do a route, and the route is a very long route, and there's really no way to do that route perfectly. Like you can only push the plow across if there's anything left once the plow has gone over and you put the salt down. Well, that is what it is, right? And then we come in with our little microscopes looking at this one place at this one time, which you couldn't possibly in real life address like the way that we examine it. But that certainly the GPS records give us more information about that particular place, and that maybe not the particular time of the accident, but the particular time that we went over that location.
Sheila, I'll just jump in just to let everybody know that because I am mindful of time and we are over what we had originally scheduled for today, but we will carry on. If anybody has to jump off, this is being recorded, so you could always pick it up at a later date. So I just want to mention that in case anybody does have to leave. Thanks.
Yeah, and I'll be done very quickly. Yeah, and I know that the dash cam footage and so on, very expensive probably. And hopefully the cost of these things is coming down, and maybe it will become much easier. In any event, in terms of the record keeping, the one benefit of these sort of technological solutions is it kind of eases the burden on the actual operator, because you can't really drive a truck and be writing detailed diary entries about what you're doing and observing and where. That's often a problem that we face, is that, we get a series of questions on like, okay, when you made this record as you were driving? No, I pulled over it. So you pull over every, like every block you're pulling over and you're writing a note, or and the sort of the implication is, ultimately, like, you're not really, this record isn't contemporaneous. You come back and that's why you're putting a line through the whole thing, because you said you did it. And then you're going from memory about what it is that you saw. So we need to be making sure that when we design a system, that it is feasible, that it's credible, that we're doing it properly, and we're doing what we say we're doing when we're doing it. We can maybe be doing some work to verify that people are doing what they say they're doing, and we get a series of questions too that are like, how, that you sent the operators out and they plowed the roads, and did you go and see that they did it right? Like, did you drive behind them or go do a patrol afterwards to see that the roads were cleaned, right? And not that that's a necessary thing, but we get those kinds of questions about, was it done properly? Because that's where they think they might be able to score some points. So if we can do something or some things just to, keep ourselves credible, if we do a little bit of auditing from time to time and just can show that we're doing some auditing to make sure that people are actually doing what they're supposed to be doing, that's helpful. In any event, what I would say is a practical records keeping system is one that is geared to success, and where it's easy for operators to be making the records they're supposed to be making when they're supposed to be making them. And so we can think about it really practically, like, where are they when they're making a record, and how are they going to do it when they're at that place? And, that kind of thing, because we're going to be asked questions about that. And the goal of asking questions about our records and why our records are the way that they are is, if we don't have our records, we don't have our proof, right? So we shouldn't be setting up an impossible system we should be making sure that our system is very feasible and that we're making good and credible records. This is a bit of an issue, this beat organization. It comes up again and again. And so, you know, some beats are, you know, here's a whole bunch of streets and here are the priorities and then here are the lower priority ones, and they're all kind of on the same list. But like to get from one street to another, like how do you do it? And so sometimes you're doing lower priority streets when, you know, between higher priority streets. And I think it's fine if you're getting them all done within the time frame for the highest priority streets, and maybe setting out an order of priorities or an actual route is useful, so that it can be estimated when a person was in a particular location if we don't have the GPS records, for example. And of course, any beats should take into account the on the ground reality of maneuvering the plows. Like you know, in some municipalities, the routes are so long that they can't actually go around in a circle. They're actually backing up, and you know, they do a street and then kind of back up or do a 3-point turn or something. And so taking into account these on the ground realities is important in the route design. And I would suggest documenting the route, why it's the optimal route, and then making sure people are following the route and that those routes can be completed within the appropriate timeframes. Okay, so thank you very much. I'm sorry for speaking at such high speed and for going over all the same. The takeaways are, we want to help you get credit for your good work. To get credit, we need to be able to prove it, and sometimes a decade or so after the fact. So it's all about record keeping, and we are here for you. So thank you very much.
Great. Thank you very much, Sheila. Thank you, Paul and Charles. I know that there were some questions coming in through the chat, and Paul, you were in there answering quite a few in the chat. Is there anything specifically that you'd like to address to the group?
No, I think we had a good little conversation on the side there, and shows good engagement. So happy to answer any of the questions that come in.
Okay. I'm just going through here to see if there was anything in particular that came in that we didn't.
I thought there might have been one about Charles's, wasn't there? It was from Greg Demers. We currently use a weather monitoring system that has red, but digitally tracks who opened and read the weather report. Does not allow for comment, but does recognize time, day, and who opens it. Will this satisfy the weather monitoring requirement? All decisions are tracked in a written log. I'll let Charles answer that.
Yeah, thanks. It kind of does, but to be honest, you need to show that you monitored the weather in the sense of air temperature, wind, and precipitation. I know this sounds very kind of like over the top, but in order to establish a regulatory defense, you have to strictly show that you complied with it. And so, you know, tracking who opened it and the fact that it contains those data points as defined as weather under the MMS is great, but it really needs to be logged properly. So, you know, if I were a plaintiff's lawyer and this evidence was presented, I'd try and pick it apart that way. I'd try and say, well, okay, you've proved that the weather forecast current and for the next 24 hours came in, it was received, and the document opened. But how do I know that this person looked at those things that are defined as weather under the MMS? And the problem at trial is you'll call the witness who received the email, who's noted as having read it, and they'll get in the witness stand and say, "Oh yeah, I know I read it." And then on cross-examination, they'll be asked, "Well, how do you know? Do you have a specific recollection on the morning of January 25th, 2019, of opening this particular email and reading not only the weather forecast generally, but air temperature, wind, and precipitation, current and forecast in the next 24 hours? Do you have an independent memory of that?" Now, unless the person has a photographic memory, they're not going to, they're going to say, I don't remember. And the problem with that is that, you know, you can testify about your general practice, but the way the law has evolved, if you can't show the court you didn't, then the court isn't going to find that you did do it. If you don't have a specific note that you've looked at air temperature, wind, and precipitation, you're not going to be successful in my view, of establishing a weather monitoring defense, which means for the winter maintenance sections of the MMS, you're not going to have a defense under all of those sections, certainly not the ones that require proof of monitoring the weather. It is why I've gone on at length in my presentation today about this very important evidentiary issue. So it's great what you're talking about. It's extremely helpful, and it's nice point in time. You can show when it was opened on the day in question, and they looked at the report, but they should note in the log those 3 data points. And if it could be updated in the software, that would be great. I think there's a product out there for anyone who's listening, who's into this, that you could improve and maybe make some sales with, because the easier you automate this, the better it is for the lawyers and for the customers. So that's my long-winded answer.
Great. Well, I've just gone through the chat. I think we've covered all the other questions that were asked. So if there's nothing else that the group has, I'd just like to take this opportunity to thank our panelists, Paul, Sheila, and Charles, for sharing your legal expertise with us today. Also like to thank Kelly Elliott from AOR's Communication and Marketing Specialist for her hard work behind the scenes today to make today's event possible. Also like to thank all of you for sharing your time with us today. But also to thank our Public Works members and staff on this session today. It is, as we said, National Public Works Week. So on behalf of the panelists, BFL Canada and AORs, we just want to thank you for all the great work that you are doing out there. So as I said before, session is recorded, so you'll be getting a link for anyone that did register. It'll also be on the AOR's website and in their weekly newsletter as well, so you can share that. And if there is any questions that you have that we didn't get to today, any topics of interest for future webinars or sessions, please just connect with Kelly Elliott at AORs and send that through to her. So thank you very much, and enjoy the rest of your day.
Thank you, Jolene.
Thank you.
Thanks, Julian. Bye, everybody.
Thanks. Bye.